Are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Okay, good morning. I am Justice Diana Maldonado, and I'm fortunate, and so are you, to be joined this morning by Justices Henry and Justice Wendlandt. We are your panel for this morning. I want to thank you for participating in Zoom or this virtual oral argument. We have 6 matters on the list today, and each case will be brought in individually. I do want to remind you that the same rules that apply when we're in court apply virtually, 15 minutes for every side. There is no time for rebuttal. The panel has reviewed your briefs and familiarized themselves with the cases, so you can use your time however which you want to get back to your points, your most important points. If we will have a time clock that will appear where right now the court seal appears. It doesn't give you a yellow light, but it will count down the time. And at the end of the 15 minutes, you'll see it'll turn to red. If you have made all your arguments before the time clock gets, so before the 15 minutes, you can feel free to end your argument. If, however, you have not, you can rest assured that we've read your briefs and we will consider all your arguments that are in your brief. With that said, I'm going to call the very first case, Commonwealth versus ALBERTO Carrillo-Martinez, and we will begin with Counsel Gravina. All right, thank you.
Good morning, Your Honors. Attorney Dana Gravina on behalf of Mr. Carrillo-Martinez. This case involves the denial of a motion for new trial in which Mr. Carrillo-Martinez had asserted that following his guilty plea in this case, he learned of new evidence which would have caused him to refuse to plead guilty in this case, and he would have insisted on going to trial. That new evidence is the Palmer video, which is referenced in the defendant's brief. In that video, what the defendant maintains in his affidavit is that in that video, one of the officers who participated in the execution of the search warrant in his case, Officer Bigda, is seen in the video threatening to plant evidence, saying that he is willing to distort the truth, hide the truth in order to fit his version of the facts.
Let me ask you, he's threatening, as I understand it, he's threatening in the video to plant evidence, distort the truth, lie. But is there any evidence of any evidence of any cases where he's actually done that?
Not to my knowledge, Your Honor.
So how is the threat in trying to elicit a plea enough to say that it would even come in on your case, for example?
Certainly. So if the case had proceeded to trial and Officer Bigda was called as a witness in order to testify as to what he recovered during the execution of the search warrant, defense counsel certainly would have been able to impeach him with the fact that he had made these assertions, that he was willing to plant evidence, that he was willing to distort the truth. I would state I can't see how on cross-examination those facts would not have been facts that could have been inquired about on cross-examination.
Let's say you're correct that he could have at least been impeached with those statements. He can't be impeached with statements that did not exist at the time of the trial, right?
Correct.
So at the time of the trial, those statements did not exist.
Well, there never was a trial. But
even if there had been, even like, on today's day, I'm not taking the plea, bring the 12 down or 6 down, right? Bring the jury in. Those statements didn't exist.
I think again, we don't know that the case that day would have gone forward to trial. There may have been other motions that could have been filed. There may have been other issues that would have been litigated in preparation. But I understand what you're saying. And I think that had there been a trial, the argument now would be a different one. The argument now would be that his trial would have to be overturned because of newly discovered evidence, because we now know that this officer was willing to do those things, was willing to plant
We
evidence.
don't know that he was willing to do those things. We know that he was willing to say that he would do those things, and there's a difference, right?
There is a difference,
Okay.
but I
So
think that
you're saying even if this had gone to trial, you would say this is newly discovered. How would it have been used then? Because what you said before is it could be used to impeach, but it can't be used to impeach. So how would it have been used then on a basis for a new trial?
if the case had gone forward to trial,
Right.
I think what it shows is the state of mind of the officer. And I don't think it was a state of mind that only existed in February of 2016 when he was captured on video. I think that state of mind, certainly, the argument can be made that state of mind existed back at the time of the execution of the search warrant in this case. It would have existed at the time of the trial. The officer doesn't state, in the video, I am now willing to plant evidence. I am now willing to hide the truth. He's stating, I'm willing to do those things. So I think that would have been grounds for
the video.
I'm sorry.
Counsel, this is Judge Wendlandt. Did you submit the video?
I did not submit the video. What we submitted was an affidavit from Mr. Carrillo-Martinez in which he accurately describes the content of the video. The relevant issue here is what effect this video had on Mr. Carrillo-Martinez and the decision that he made or the decision that he did not make. And so the affidavit from him, I would state, is the key piece of factual evidence in the case. No one has ever disputed the contents of the Palmer video. The Commonwealth now doesn't dispute the contents of the Palmer video and that they're accurately reflected in the affidavit.
My other question, Counsel, is did you submit the articles that were referenced in the motion for new trial?
No, those were also referenced in Mr. Carrillo-Martinez's affidavit. What we requested in the motion for new trial that was filed and what we're still requesting at this point is that the case be scheduled for an evidentiary hearing where these issues can be further explored, where we can call Officer Bigda as a witness, where we can call Officer Vigneault as a witness. We have not had the opportunity to do that at this point. What we have is these articles. What we have is this video, and we have a defendant who's saying that I've now learned about these things. Had I known about them, I wouldn't have pled. I would have gone forward to trial. I would have insisted that these officers take the stand, and I would have cross-examined them and sought to impeach them.
Now, Commonwealth points out that some of the evidence was discovered by the other 6 officers that conducted the search.
Correct.
I'm wondering how that affects the analysis here. That is, Officer Bigda was not, at least according to the Commonwealth, necessary, not a necessary witness. That a different officer could have been the witness.
I would state that with respect to the narcotics that were found, they were found by Officer Bigda, and so he absolutely would have been an essential witness with respect to the discovery of that item. He also found additional pieces of evidence that would have certainly been used at trial. I think another fact that would have been explored at an evidentiary hearing is this claim from Officer Vigneault that he was told to keep his mouth closed about things that he saw Officer Bigda do while he was on duty. And so I would state that that's certainly something that would call into question even what these other officers recovered. In addition, Officer Bigda's assertion himself that he was willing to plant evidence, just because it was found by another officer doesn't mean that it existed before Officer Bigda walked into the room. He could have planted anything that could have been found by these other officers. So I don't think that argument is sound or logical, that because these other officers found these other items, that is grounds to deny the motion or deny an evidentiary hearing. As I stated, Officer Bigda could have planted the items that were found by those other officers. And it clearly appears that there was some sort of culture there where these officers were willing to turn a blind eye to the things that Officer Bigda was doing.
And is
And
that
so I,
the test under Scott that this government misconduct could have resulted in tainted findings?
I'm sorry, could you, I missed the first
So,
part
you know,
of the question.
under the Scott test, right, there's a two-pronged test, right? And the first prong, you have to show that it affected this defendant's case.
Okay.
Yeah, so I'm wondering, is that your way of establishing that prong, that the fact that Bigda in the video, as told by your client, is threatening to plant evidence, suggests that on a prior occasion, he did that, could have done that?
That he could have done that. If the court was to analyze the claim under that test, under that standard, you know, our contention is that, you know, the claim is properly, the standard that should apply to the claim, and the analysis that should take place here is whether or not this is, you know, something newly discovered, some new fact that Mr. Carrillo-Martinez learned of post his plea, and whether or not, had he known of those facts, he would have pled or would have insisted on going to trial. I think that, you know, we're suggesting that the court should not analyze this under the framework that was set out for, you know, claims regarding Annie Dukin and her misconduct, but should analyze it more along the lines of a Padilla claim, where you know, you're claiming that your client did not know of some important fact that would have impacted the decision they made to either go to trial or not go to trial, and that had they known of that information at the time of the plea, their decision would have been different. And that's,
why do we apply that Padilla standard when the Scott standard is specifically directed towards government misconduct in connection with the plea agreement that is learned by a defendant after?
well, again, I think that, you know, that framework was set up to deal with, I think, a specific issue of the Annie Dukin scenario.
Well, it was applied in the Annie Dukin scenario, but it comes from the federal standard, which has nothing to do with Dukin.
And what I would state is, again, I think that our contention is that that's not the proper way to analyze the claim, that the proper way to analyze the claim is more under a traditional.
But yeah, I guess that's the core of my question. What tests do I, as a judge, apply? You're suggesting that it's not the Scott standard. I'm telling you that the Scott standard derives from non-Dukin cases involving precisely the kind of misconduct you're alleging here. So why do you think that doesn't apply?
I think the difference is that you've got if it was a specific case where the officer had planted the evidence in a case post Mr. Carrillo-Martinez's case, then I think that that's a little bit more akin to what Scott is talking about. You know, a specific instance of misconduct where the officer plants evidence. But here, what we have is an officer talking not about or an officer not committing one distinct act, but it's his mindset, it's his willingness to, his statement of a willingness to do this in a variety of cases. You know, it's a willingness to do this not only this one time, but saying, you know, I can, if I don't say something happened, it never happened. Well, that's not a specific instance. That's a mindset. And the same thing with his stating, you know, I can pin the Kennedy assassination on you, or I can plant, you know, a kilo on you and put you away for 15 years. I mean, those are going to the state of mind of the officer. So I'd state that it's not a one specific thing such as, you know, what a lot of the cases that apply that Scott framework apply to. This is the character and the willingness of this officer to do certain things. And that's what I would say is differentiates it. And it makes it more akin to, you know, something that should be analyzed under that Padilla standard, where the question is, what did the defendant know about the people that were involved in, or the facts, or the, you know, the mindset of the officers that are involved in his case? Is there evidence that he's learned of that would have been admissible and could have, you know, affected how that trial would have looked? And I'd state here that the answer is yes. He's saying there's facts that had I known of, I wouldn't have pled. So I'd say that's the relevant inquiry, and that's the standard which the court should apply. And again, you know, the standard that we're under here is whether or not we raised a substantial issue entitling Mr. Carrillo-Martinez to an evidentiary hearing. And so I'd state certainly his affidavit, in which he's setting forth these undisputed facts about what happened, entitle him to that evidentiary hearing, in which he could further question Officer Bigda. He could further question Officer Vigneault in an attempt to further establish facts that would support his claim. He's raised that substantial issue, and I would ask this court to remand the case for an evidentiary hearing and give him the opportunity to litigate these issues in court, which he has not had at this point.
Counsel,
And I see I'm out of time.
all right, no questions? Hearing none, okay, we'll hear from counsel.
Good morning. May it please the court, David Shepard-Prick on behalf of the Commonwealth. The defendant presented no admissible evidence of government misconduct to the motion judge. Additionally, even the evidence.
Well, let me ask you.
Yes.
Go ahead, Judge Maldonado.
No, it's okay, go ahead.
You don't dispute that. I mean, this videotape has been widely shown. It's on the internet. Some of us may have seen it at the time that it occurred. You don't dispute the existence of the videotape that Bigda made these statements, right?
No. No, but I mean, it's certainly in existence, but it's still the defendant's burden to provide the court with admissible evidence.
But counsel, we need integrity in the system, right?
I'm sorry?
We need integrity in our system, correct?
Of course, and I think
we have an officer here that everybody understands did, maybe not in this particular case, but he is on videotape doing something that is unacceptable and undermines the integrity of our system, right?
I completely agree with you.
Thank you.
And isn't the affidavit enough to raise the issue, as counsel says, a substantial issue? And then the question is, what will you explore during a hearing? Don't you think that having raised this officer's credibility, integrity in such a way that it would at least allow for the opportunity to find how much of this has it done? Has it been this one occasion, or is it a pattern that is wider and in fact covers the umbrella of cases that Mr. Carrillo-Martinez fell under? I mean, isn't that exactly what the hearing is supposed to do? I raise an issue with this officer's credibility, serious issue with this officer's credibility, that we don't know if it did or didn't affect this case, but that's what the hearing would do. Allow us to explore that to make sure that it didn't, in fact, invade this case.
Well, except that the Ferrara-Scott test requires that the defendant prove government misconduct that predated the entry of his guilty plea. And here, the incident that we're discussing happened 4 months after he pleaded guilty. So it can't have predated his plea as required by Scott.
Except that his credibility is always at issue. So once you know that this officer has some serious defect in his credibility, then a hearing would allow you to discover whether that that character misflaw, or whatever character flaw existed even before that one video.
Well, again, I go back to the fact that it's the defendant's burden to show that this took place, to make a substantial a showing before he's entitled to a hearing. And the motion judge was totally entitled to reject the defendant's affidavit as not credible, as it relates, again, not to the existence of the video.
Not credible?
We're
We're not saying that the officer didn't do this. So you're not saying not credible, you're just saying not temporal, right?
Well, I'm also saying not credible as to the claims that it would have altered his decision to plead guilty, which I think is the second issue in which the motion judge properly rejected a claim of it for an evidentiary hearing, because what the motion judge said is basically he was facing 8.5 years mandatory minimum, potential life sentence, 95 years total altogether on all charges. Even if there had been misconduct proven in this case, it would not have been reasonable to reject the plea offer and go to trial, because the Commonwealth could prove the case without Officer Victor. There was, he recovered the large quantities of narcotics, but all other officers recovered a scale with residue, packaging materials, other instruments of the drug trade, firearms. All of those charges, including the possession with intent, could have been proven without.
Defense counsel has argued that if other officers knew that Bigda was doing these things, or at least saying these things, and not intervening, that would have actually tainted all of the officers. So what's your response to that?
My response to that is, your question is if they knew, and there's no evidence that, certainly credible evidence that they knew. What the defendant put forward is a multi-level hearsay statement by a police officer who was not involved in this investigation, but was criminally charged for his participation in the Palmer video incident, alleging that the Detective Bigda at some point in time drank while he was on duty. There's no allegations with, even assuming that type of, that three or four level hearsay was admissible. There's no suggestion that Officer Vignault said anything about Detective Bigda planting evidence or falsifying police reports or anything like that. So there's no suggestion that anyone knew about any type of misconduct other than potentially drinking while on duty at some point in time.
So the defendant argues that the Ferreira-Scott framework's just not the right framework for us to be considering, that the issue is this is really newly discovered evidence that would have affected the defendant's calculation about whether to plea. So what do you say to that?
Wait a second. I think we lost
counsel.
Just 1 second. Wait, I think we lost Judge Wendlandt. Can you stop the clock, please?
The question, what I would say is the Ferreira-Scott framework is the appropriate framework in which to analyze the defendant's claim. I would point the court to Commonwealth versus Rescendi, cited in the Commonwealth's brief, where where the SJC dealt with an incident of government misconduct. In this case, in that case, it was the misconduct of Annie Dukin, and that had occurred in that case 1.5 years after the defendant's sample was analyzed, and the court in Rescendi addressed it under the Ferreira-Scott framework and said, one, that doesn't apply in the sense that it's not newly discovered evidence that warrants granting a new trial. I would also say
see, that's not the newly discovered, I guess, because at that point, everyone, the anti-doping issue was out there, correct?
It was out there at the time of
So
the case,
here-
at the time of his plea.
Okay, but I guess my problem here is you have this information that, yes, it comes after the plea, but is it enough to say we should look into this? Like, I guess my problem here is the fact that there wasn't a hearing to explore whether there was information. This was enough to bring to the trial court's attention, substantial enough to say, we need to further investigate. I mean, maybe it will produce nothing after hearing, but enough to put this man on the stand and find out, or his colleagues on the stand, how many times has he said this? How many has he ever really executed on this? And I guess that's why isn't this substantial enough to raise the issue for a hearing as to whether this conduct is not limited to that one video?
Well, a number of reasons. First is that, for the reasons I already that set forth, even if he had proved government misconduct in his case, it would not entitle him to a new trial or to withdraw his guilty plea, because the case could have been proven without that detective, and so it would not have been rational, given the amount of time that he was facing, to reject the plea offer. Additionally, there has been a full investigation and pending criminal charges against this officer for this incident. So the fact that there is other information out there, none of which was put before the motion judge, which, again, from what is out there, there is nothing more than the one incident that has been the subject of the federal criminal charges. So I think the motion judge was proper in rejecting the claim, both because he hadn't provided the necessary admissible evidence, and even if he hadn't proven established that it could have occurred or did occur in his case, and even if it did, it would not have been rational to reject the plea offer.
So are you saying that the information that there was a more thorough investigation was also out there, and that more thorough investigation never produced any evidence that either this conduct existed before, this conduct was actualized, or that other officers were did a blind eye to his conduct?
When you say his conduct, if you're referring to his drinking, there was evidence of his drinking on duty after, generally it was drinking on duty after they had completed whatever task they were doing. They were in the office. This was presented in the federal case, but in terms of planting evidence or filing false police reports other than for the night of the incident, there's been no evidence of any sort of widespread misconduct.
Yeah, and you're saying that at the time of the filing of Mr. Correa's affidavit information, all that other information about the investigation and what the investigation produced was also available to him, or not?
It was available, yes. It had been reported widely in the news. There was no post-conviction discovery request in this case. It could have been produced to him if he had requested it.
Well, isn't asking for a hearing kind of that trying to say, I want to know more? Isn't that what you do?
Well, I mean, I would say, having just responded to a number of post-conviction discovery requests in the past few weeks, there is a proper mechanism under Rule 30C to request post-conviction discovery while your motion for new trial is pending. Additionally, our office is always ready to share post-conviction discovery to the extent that it's relevant and does not impact ongoing investigations.
In response to the defendant's motion, was there any response that produced that basically said, this has been explored and investigated, and there's no evidence that it extends beyond this one video?
No, the response simply address the issues the defendant had raised, because again, there was no request for discovery.
So Bigda was the only one that discovered, I guess it was cocaine. Is that right?
He was the only one who discovered any large quantity of cocaine.
Right. The rest was just residue, right?
Correct. Residue on scales and other packaging materials, yes.
And so it's still your position that it's enough for the intent to distribute and the distribution of cocaine? Both, all three of those counts?
That's correct. I would point the court to Commonwealth versus La Pearl, cited in the Commonwealth's brief.
So that's intent to distribute. Is there any case that you could cite for me with regard to distribution?
With regard to distribution, no. But the distribution, the possession with intent, those carry, as a subsequent offender, carry a very similar sentence. In this case, they were served concurrently. So I don't know that perhaps the distribution could have been proven, but the possession with intent as a subsequent offender could have been. So he would have taken the same amount of time for that charge, regardless of whether we could have proven the distribution or not, as well as the firearms charges. Unless the panel has any questions, I'll rest on my brief.
Okay, seeing none. All right, the case is submitted and very interesting case. Thank you both. Go live. And
We are live.
okay, calling the case of Carmel versus ALFREDO Serrano-G, 219P 1023. Okay, counsel.
Good morning, Your Honors. Rod Aresti for the defendant Alfredo Serrano-G. May it please the court, the main issue in this case is whether there was sufficiency of evidence, essentially, whether the evidence was plausible, whether there was plausible evidence that Ms. Shackle had a possible motive to fabricate her complaint. And if there was plausible evidence of such a motive, was it enough to create enough reasonable doubt that a rational fact finder could not have concluded an indecent assault and battery happened, even in the light most favorable to the Commonwealth?
Does that posit require us to weigh credibility?
It doesn't require you to weigh credibility. The trial judge does have broad discretion when weighing the facts in the case. However, that's not carte blanche discretion. It's still guided by the standard of Lattimore, reasonableness and fairness, and whether or not the evidence was sufficient. Now, in Mr. Serrano-G's case, Ms. Shackle, or the Commonwealth, relied solely on Ms. Shackle's testimony to prove the elements of indecent assault and battery. And when that credibility comes into question by evidence of not only delay, but also of discovering these photos that she sent Mr. Serrano-G online. They were nude photos online on a website. And she also, after the alleged assault and battery, she also met with Mr. Serrano-G again. All of these facts that came in at trial, they weakened her credibility. And whether or not, the question, the overarching question is, was that enough for a reasonable fact finder to conclude that?
Let me ask you. So, by the way, we are at a disadvantage because we don't have the transcript of the trial, or are we missing something here because we were not able to locate that? Was that somehow produced? And if so,
no, I believe that the transcript was produced, Your Honor. There is a transcript of the trial.
Oh, really? Okay. So for some reason, maybe it just didn't, I didn't get it.
Oh, okay.
But all right. But anyway, we can, it doesn't seem to be a dispute on facts. So that's why I was going to ask, is it undisputed that she was asleep at the time? Is it undisputed that she was asleep when that touching occurred?
This was Ms. Shackle's testimony. Again, Your Honor, all of those facts that came in that where the court, which convicted, where the court found that Mr. Serrano-G was guilty of indecent assault and battery, came in through Ms. Shakel's testimony. And at trial, what happened was her defense counsel sort of weakened her, did weaken her credibility by bringing up that there was a delay of about 5 months in reporting the crime to the police or making a complaint to the police.
No, but there was nothing, so you're saying that her testimony was so incredible that even if she said, this happened while I was asleep, the judge should have disregarded everything she said because her testimony was so incredible.
Right, so through
is
testimony.
that your argument, that her testimony was so incredible that it could not be accepted even in the light most favorable to the Commonwealth beyond a reasonable doubt?
Correct, Your Honor. And just to kind of review the facts here, through the testimony, what came in, the relevant evidence that entered was they met on Tinder and Plenty of Fish, which were popular websites for individuals looking for sexual encounters at the time. And then they
was there evidence, by the way, was there evidence at trial describing what Tinder is?
No, the only evidence that came in was that it was a dating app.
Okay, so it wasn't described as a dating app for sexual encounters.
Correct, Your Honor.
And we can't take judicial notice of that.
I guess not, Your Honor. But
so all we know from the trial is they met on a dating app.
On a dating app. And we also know that they exchanged texts, and Ms. Shakel sent a nude photo of herself to Mr. Serrano-G. They met at Mr. Serrano-G's bar where he lived upstairs. She didn't want to drive home. She had a few drinks. She didn't want to drive home. She went upstairs, and then she in her testimony, she said that she woke up and Mr. Serrano-G had her breasts out and was feeling her breasts. And then
Counsel, if she had gotten up the next morning and gone directly to the police, do you agree there would be sufficient evidence to support a conviction?
Well, I think that then you're taking out the delay, the delay factor, which is significant here. Now, delay does not mean that there was no consent, but considering the circumstances in this case, where not only was there delay, the delay, it seems that the complaint to the police was triggered by the discovery of the photos on the internet.
So let's just stop at the night in question, and she gets up the next morning and goes directly to the police. Then was there sufficient evidence to support the conviction?
I think that is that's more sufficient than what we have here, Your Honor. I do. But I cite to Kennedy in my case, which is a similar case where the defendant and the victim met online on a dating website. They exchanged texts. They met at a gas station. They went back to the victim's house. In that case, however, the defendant exposes himself and makes and gets very aggressive with the victim to the point where he forces her basically to touch his private area, and she says no means no, and he leaves. And then immediately after, there was another witness, a first complaint witness, where she texted her friend to say that all of these things just happened. In our case, all you have is Ms. Shakel's testimony. And in Ms. Shakel's testimony, she also says, I met with Mr. Serrano-G again to confront him, and my sister was present. Her sister was there.
Right, so just leaving all of that aside for a moment, can a person who's asleep, I mean, are you contending that a person who's asleep has consented. Like if she's been part of, on these facts, that she met him on the dating app and she sent him this picture and she went and she spent time with him and she got into his bed and went to sleep.
Not at all, Your Honor. I am not contending that a person sleeping has consented. My main contention, Your Honor, is that once her credibility is weakened, and if the Commonwealth is only relying on Ms. Shakel's testimony, once her credibility is weakened, is it enough to find sufficient evidence to convict Mr. Serrano-G on indecent assault and battery? And
We're not saying weakened only. You're saying that her credibility was destroyed.
I am saying her credibility was destroyed enough that there was reasonable doubt that you could not conclude that Mr. Serrano-G committed an indecent assault and battery.
So you're saying that her credibility was destroyed such that you couldn't believe any part of her story, including the fact that she was asleep.
Right, and a significant part of that is what happens in between the date of the complaint, of when the crime happened and when she complained. And what happened was she met with him. She was not scared. She met with him once again soon after. They texted. She ended the relationship. When she ended the relationship, she found those photos online on the website, and subsequently after that, she makes a complaint to the police. And
Well, didn't she testify that she was trying to, she met with him to diffuse the situation, and that she was in fact unhappy with what happened, and that she was in fact afraid?
she met with, yes, she said she met with him to confront him about what happened. And I don't think she said she was afraid, but usually when someone is afraid, they don't meet, they're not going to meet with someone in their car at night. Now, granted, her sister was with her, and we don't know, the sister did not testify at trial.
So usually credibility is for the trier of fact. What authority exists that we could say that the trier of fact did not have the power here to believe her?
Right. So as I mentioned, the judge does have broad discretion, and I'm not saying that the judge doesn't have broad discretion. What I am saying is that under Lattimore, with all of these facts, with all the circumstances that happened in between the actual, the alleged crime and the complaint, enough factors, the factors that came in, there was enough reasonable doubt that a reasonable fact finder could not conclude that Mr. Serrano-G committed an indecent assault and battery.
Do you
Is there
have
a case though that where the court has held that as a sort of as a matter of law, really is what you're asking, that a witness's credibility has been so destroyed that a reasonable fact finder could no longer credit it?
Right. So in this case, Your Honor, the you have the delay. You have the delay in the complaint, the triggering event of discovering the photos. You have the meeting, the texting back and forth within those 5 months. So the judge, like I said, the judge has broad discretion, but you have, I cite to Commonwealth versus King and Commonwealth versus Avila's, where delay is just one factor, but you also have other factors to allow.
No, I guess the question is not what things you look at to destroy her. Do you have a case that says that a judge, that the credibility of the witness is so weakened or destroyed that a judge, as a matter of law, we can say the judge could not have reasonably found her credible?
No, Your Honor, I don't have a case law that says that explicitly, but there are cases which I cite in my brief where the judge, you're allowed to consider all of these things under a Lattimore standard, all of these events under a Lattimore standard. Was she credible enough that there was no reasonable doubt? And I don't think there is. If that's no questions, I'll rest on my brief and give up the rest of my time.
All right, counsel. Take yourself off mic. There you go.
Okay, here I am. Sorry about that. Good morning. May it please the court, Abigail Solois on behalf of the Commonwealth. If I may quickly, a little housekeeping. If my memory is serving me correct, I think I did file a copy of the transcript with the court. I didn't want to check the docket while we were on Zoom here, but after the argument is finished, I will check that. And if you don't have it, I can submit it following our argument today.
Okay.
The Commonwealth respectfully requests that this court affirm the defendant's conviction of indecent assault and battery. Where the victim was sleeping and the defendant sexually assaulted her, there was sufficient evidence of
Can I just interrupt you, because
of course,
we all agree that you can't consent to when you're asleep. So
yes.
the question here isn't so much whether you can consent. I think the question here is it possible for a witness's credibility to be so destroyed that as a matter of law, a judge cannot reasonably accept it?
No.
And I can imagine, for example, that if you had a witness who is completely hallucinating, and there's evidence that all they did was hallucinate through this thing, a bunch of acid talking about, and describes an act that it was impossible to happen as that person described it. And we know that you might have to say, as a matter of law, you can't accept that testimony to support a conviction. So I'm not sure that I'm aware of some cases that hold that. There might be from before that maybe are not necessarily old cases. But are you aware of any cases that say that? Or do you think it's impossible for that ever to be the case? Not saying that this is the case, but do you think that it's impossible for that, for an appellate court to ever say that a witness's credibility is so destroyed that as a matter of law, the judge could not have found proof beyond reasonable doubt?
So to answer your question, no, I'm not aware of a case that says that as it stands now. I'm sure we could create a set of facts, as Your Honor mentioned, where someone was hallucinating and completely made the whole event up. Sure, perhaps that could be true. But here, having bias or motive to lie does not mean that a judge cannot credit the witness as a matter of law. That's not the law in the Commonwealth. And in this case, the defendant, in his brief, he seems to have combined credibility with sufficiency. And that's problematic because, of course, we have two different standards of review. For credibility, we're under an abuse of discretion standard. For sufficiency, we're under a Lattimore standard. And he argues that the evidence of non-consent was insufficient because the victim fabricated her complaint in retaliation against the defendant. But it's well settled in our case law that the weight and credibility of witness testimony are for the fact finder. And if looking at pages, I think it's around 12 or 13 of the defendant's brief, he relies on cases like I might be pronouncing that wrong, to argue that the Commonwealth failed to meet its burden because the victim had a plausible motive to lie. But the actual issues in those cases were different. They were cases about a judge's ability to limit the scope of cross-examination about bias and motive to lie. And here, Judge Harbour did not limit in any regard, in any way, the defendant's ability to pursue evidence of bias or to cross-examine the victim. And as the trial ADA argued in closing, the defendant argued an ancient misnomer about sexual assault in this case, that women, and you may not know this because if you haven't read the transcript, but he essentially argued that women, by the way they behave or dress, somehow asked to be sexually assaulted. And that's at page 66 of the transcript. And I just want to make clear that a victim's poor judgment does not equal consent. Did Ms. Shackle make some bad decisions? Probably, but that doesn't mean that she consented to being sexually assaulted in this case. And as just speaking a little bit to the delay factor, I just wanted, I know the court's familiar with the King case, and the court recognized in that case that Victims often do not promptly report a sexual assault for many reasons, and those reasons may have nothing to do with fabrication or credibility. For example, the victim in this case, at many times, 3 different points in the transcript, talks about her fear of the defendant, and that may very well have been the reason that she delayed. Of course, the victim became upset when the defendant disseminated nude photos of her on the internet without permission. Of course, she was upset. And her upset may have motivated her to report the assault to police after 5 months. But again, that doesn't mean that the assault was fabricated. And Judge Harbour, who observed her testimony, was entitled, within his discretion to make that credibility determination. I'm not going to go on and on. I think this case really does boil down to credibility, not sufficiency, because she was asleep. So I won't take too much of the court's time. I will happily answer any questions that you may have. And if there are no further questions, the Commonwealth respectfully asks the court to affirm the defendant's conviction, and thanks, Your Honors, and rests on its brief.
Okay, thank you. The case is submitted. Good arguments on both sides. Interesting. And we'll go live.
We are live.
All righty. And calling the next case, Commonwealth versus Gregory Pierre-Charles, 219P0650. And we'll hear from Attorney Noonan.
Thank you, Your Honor. May it please the court, Patrick Noonan for Mr. Pierre-Charles. I would like to start with the motion to suppress argument. And the key argument here is that there was an insufficient nexus to establish that drugs would be found in Mr. Pierre-Charles's home to support the search warrant. The evidence that the affidavit relies on to establish the nexus is 2 controlled buys with a confidential informant at some undisclosed.
So let me ask you, why is that not enough if the officer saw that they watched the controlled buy set up, they saw your client leave the residence right at the time when the controlled buy is supposed to take place, then the buy happens, and then they see him returning? Like, why isn't the case so suggest that the leaving and the coming back is enough to say that the drugs were in the home and that the monies or whatever proceeds were going back to the home?
Yeah, so back in with Commonwealth versus Smith, that case held that if there's one controlled buy and the police surveil the defendant going from his house to the buy location and doing the buy and going back, even though he's surveilled from start to finish, one controlled buy is not enough to establish a nexus if there are no other facts there to support a nexus. Here, there are 2 controlled buys. Smith had 1 buy, but we have 2 controlled buys. And even though the defendant is surveilled back and forth, there are no other facts to establish a nexus to drugs being found in the home. And really, it boils down to just these 2 controlled buys. Is there anything else out there that establishes a nexus? And I build off of the Smith case because they say 1 controlled buy, even though there's surveillance, if there's no other facts to support a nexus, then it's insufficient to issue a warrant. And there is no other evidence of a nexus because we have an informant who really provides no information as to whether drugs are being kept in Mr. Pierre-Charles's home. He doesn't know Mr. Pierre-Charles's actual address. He's never been inside Mr. Pierre-Charles's home, and he provides no information that drugs are being stored or dealt out of Mr. Pierre-Charles's home. So he has no information that Mr. Pierre-Charles has ever sold drugs out of his home or kept drugs in his home. He doesn't really even know where Mr. Pierre-Charles lives. So I think that the Smith case says, well, if you just have 1 controlled buy and there's surveillance from start to finish, that's not enough if there are not other supporting facts out there. And there really isn't in this case, because not only did this informant have no information about where Mr. Pierre-Charles lived and never alleged that Mr. Pierre-Charles had drugs in his home, there really wasn't any surveillance.
I guess what you're suggesting is if one isn't enough, two doesn't give you much more.
Obviously, one more buy does help the Commonwealth's case, but I don't think two does it in this case because there's really no other nexus. Because the police did, in this case, from what I see, it's an 11-day investigation and it was very quick. And they did go to Mr. Pierre-Charles's home, and all they saw was a group of black males sitting on a porch. And in this investigation, the police did not do, well, they did a surveillance on that on that occasion, but they didn't, the police didn't do an independent investigation to establish that there was any drugs being sold in that home or being kept in that home. They didn't park outside and watch for any foot traffic or frequent visits. And there wasn't anything from a police standpoint to show that there were any drugs being stored in this house. The only reference to any independent investigation is that after the second controlled buy, the officers saw that there was a group of black males on the porch of the house, and one of them appeared to be the defendant. So there was really no information from a police standpoint that any drugs are being kept in Mr. Pierre-Charles's residence. They didn't.
The Commonwealth basically argues that the confidential informant established reliability by demonstrating that the CI could accomplish exactly what it said it could in terms of purchasing narcotics from the defendant. What do you say to that?
So I would say that, you know, the CI's, I guess, veracity is established by the fact that there are two controlled buys. But the question is, you know, does the CI provide any information that drugs are being stored in Mr. Pierre-Charles's home? And the answer to that question is no. So the CI delivered on his representation that he would call Mr. Pierre-Charles and set up a buy. But the question for this argument is there any other evidence of a nexus to the house? And the CI provided no such information. And there's no.
I guess go ahead, Judge Henry, sorry.
The CI was never in the home, never said there were drugs in the home, didn't even know where the home was. Is that what you're saying?
Absolutely. The only thing that he says, and I'm just referring to the CI as a he to make it simple, the only thing the CI says is that over the past several months, it had purchased what it believed to be heroin on numerous occasions from Mr. Pierre-Charles in Brockton. And then the only information he has as to Mr. Pierre-Charles's residence is he believes that this person referred to as G lives in the area of French Ave and Vesey Street. So the CI had never been inside Mr. Pierre-Charles's house, didn't know where he even lived. The only thing he got correct was the street, but certainly no information that he had ever been inside of Mr. Pierre-Charles's house. So if I could shift gears, if that's all right, to move to the second
I'll
argument.
just ask you one last question on that. So your position is not so much that the CI was not had no basis of knowledge, or was not had the veracity prong of Aguilar Spinelli is not met. It's just that even assuming the CI meets that standard, there just was no connection to the actual home.
Absolutely right, Your Honor. And this, for the motion to suppress, that is my main argument, is that there is no nexus to the home other than these two controlled buys, but there's nothing outside of those buys that establishes any nexus. So if it's okay with the court, I'd like to shift gears to go to.
I think Judge Henry might have a question for you.
Oh, yes, I'm sorry, Your Honor.
So the Commonwealth notes that it seems as if this CI had worked with this police department once, and that resulted, I think, in an arrest. And then there's reference to cooperating with, I think, federal authorities, but there's no details about that. Is that at all significant for our analysis?
So just to correct, Your Honor, there is no reference that this CI ever engaged with federal authorities. The only evidence on this CI's cooperation with the police in the past is just that it had provided information that related to a, quote, in the seizure of narcotics and an arrest. So that is the only information the CI has provided in the past. So that is, I would suggest, very, very insufficient to establish the CI's reliability. There's a lot of case law that suggests that providing information that leads to one arrest is not enough to establish reliability. Even cases that result in 3 arrests don't establish a reliability of an informant.
But
really,
here, the statement in the affidavit is that it resulted in the seizure of narcotics, not just an arrest. I thought the problem with the other cases that you're discussing is that they only led to an arrest and not the seizure of narcotics, making this specifically different in that regard.
Right. And there's no real distinction as to whether the seizure of narcotics and the arrest are 2 separate cases. They could be from the same case itself, because it's a seizure of narcotics and an arrest. I don't know if that's the same case or if it's 2 separate cases, but even if they are 2 separate cases, I would rely on my brief. I believe I cite the Mejia case, where that CI had provided information to a drug task force that had led to arrest. And in that case, they had provided the defendant's names and I believe docket numbers and courthouses and information like that. So by comparison to the cases that I cite in my brief, simply providing information on the seizure of narcotics and an arrest is really not enough to establish the CI's reliability, because there's no real specifics that are provided as to that particular case. Is it okay with the court if I move on to the required finding argument?
So you know our other questions on the first issue. Go ahead.
Thank you. Okay. So the main argument, Your Honors, on the required finding is that what we have here is a case where the police execute a search warrant at a residence and the defendant isn't home. And I believe that the evidence strongly suggests that the drugs in this unoccupied bedroom belong to a James Pierre-Charles. And those are the 2 inferences at play here. Is that inference number 1 is that the drugs in this unoccupied bedroom belong to James Pierre-Charles, and inference 2 is that the drugs in the unoccupied bedroom belong to the defendant. And I believe in this case that the evidence that these drugs belong to James Pierre-Charles is far stronger than the inference that it belongs to the defendant.
Was there evidence of James's wallet and license and in the bureau drawer as there was here of your client?
No, there wasn't. And the only evidence that links the defendant to that bedroom is I guess I'll refer to it as a wallet, but it's some sort of business card holder that has some forms of identification in there. But other than that, there's nothing that links the defendant to that bedroom.
But don't you think that's a strong link?
Well, one thing that I had put in as an exhibit was a picture of that bedroom after the police had searched it and strewn the entire bedroom apart. And they go through every nook and cranny of that bedroom, and the only thing that links the defendant to that bedroom is the business card holder with some forms of identification in there.
And where was that located?
It was located, I believe, on the top of a dresser drawer. The business card holder was. But even if you look through that business card holder, there was no cash in it, so it doesn't really have the characteristics of your ordinary wallet. There was no cash in there, and there was a lot of old expired cards that were in there that I think suggest that this wasn't something that the defendant was carrying on his person every day. It wasn't your typical wallet that's in your back pocket when you leave the house every day. You had an old school ID that was 7 years old and some bank cards that were 5 years old and 3 years old.
What evidence do you say makes the inference to James stronger?
Thank you, Your Honor. So when the police execute the search warrant at trial, the evidence was there was no evidence to link the defendant as living in this residence at all. But when they go in to search the house, they know that James Pierre-Charles lives there. And they also know that James Pierre-Charles has a warrant for drug distribution. And when they execute that warrant at the house, they find drugs in James's possession, and they determine that James possessed drugs in that house with the intent to distribute. So they charged him with possession with intent to distribute for drugs in that house that they determined belonged to James Pierre-Charles, and distribution materials that belong to James Pierre-Charles. So going into the search, they have information that James Pierre-Charles lives there, that he's got a warrant for drug distribution, and that when they execute the warrant, he has drugs on his person, which they use to charge him with intent to distribute.
But nothing to connect him to that bedroom specifically, as there is with your client.
Nothing to connect into that bedroom. When they execute the warrant, they find James Pierre-Charles in another bedroom, which is directly across the hall from the bedroom that these drugs were in. And he's right across the hall in another bedroom. And the house was described as being very tight quarters, and across the hall was a very, very short distance. And when the
Nothing connects your client to that other bedroom, right?
No, because the officer that went into that bedroom, Detective Bell, he didn't find anything that would link that bedroom to James Pierre-Charles or Gregory Pierre-Charles.
Except that James was in it.
Except that James was in it. And
that's a pretty strong link.
Well, you know, the bedroom's right across the hall. And when the police are knocking on the door and announcing that there's a search warrant, somebody that has a warrant for drug distribution wouldn't take very long for him to go from one bedroom to another bedroom across the hall. And the police in this case testified, well, we had no information that really linked James to that bedroom across the hall that he was found in. So Mr. Pierre.
So then the sufficiency, we take the evidence in the light most favorable to the Commonwealth.
Right. And I think under Croft, we have to look at, you know, which inference is, if the inference that the drugs belong to James is equal to the inference that they belong to the defendant, then the defendant's motion to require finding should be allowed. And I believe that the inference that the drugs belong to James is stronger than the inference that they belong to the defendant. So I think I may be out of time. So I would just rest on the arguments in my brief, and thank you so much.
Okay, thank you. Attorney Anderson.
Good morning, Your Honors. Audrey Anderson for the Commonwealth, if it pleases the court. There was evidence to believe that the defendant kept drugs in his house. Detective Donahue received information from the confidential informant who had provided reliable information in the past to officers, other officers besides the Detective Donahue, that resulted in the seizure of narcotics and arrest.
Did the informant provide anything? He certainly provided information that this defendant was selling drugs. Did he provide any information that he was selling it out of that residence, aside from the fact that he lived, that he lived on French Street?
There was no information in the search warrant detailing this, but Detective Donahue also stated that they had to be careful about what information that they put into the search warrant, because
but we have to look at the four corners of the search warrant when you look at this, right? So we can't talk about what was in his head. We got to talk about what he put on paper. So
he did put that in the search warrant.
Yeah, no, he put that he didn't want to describe. I'm not talking about the reliability right now of the CI. I'm talking more about the information provided by the CI. So the information provided by the CI is this person is selling drugs. He lives around French Street. I can get heroin from him, and he does, and then he fact does, right? On two occasions.
I have been purchasing.
I have been, but not that I have been purchasing it by going to 105 French Street to purchase it, right?
No, Your Honor.
Not that I hang out on the stoop at 105 Friend Street to purchase it, and he comes out and hands it to me right there.
No, Your Honor.
So all we have is I have been purchasing heroin, and then in fact does purchase heroin twice.
Yes, I have been calling a
Would you
phone number.
agree that the Smith case says, you know, that there certainly is there are certainly cases that say watching the person go from the house, commit a buy, go to do a buy from the house, and then return to the house is enough. But do you agree that Smith case says one time isn't enough?
Okay, and the courts got, this is more than once, this was twice. And the courts, Smith is still good law, but the case has gotten away from Smith. There's Escalada, I think.
How many times in Escalada?
Escalada was a lot. Escalada was just back and forth. I think the case was over several weeks. But there was also Tapia, which
And
was,
how many
I think,
times there?
two or three.
Okay.
And
Counsel, in Tapia, though, the defendant told the buyer that she had to go home. She made a statement tying the narcotics to the home, right?
yes, she did.
Okay.
She told the informant that she did.
And do we have, we've been talking about there being two controlled buys where the defendant departed from the home, but in fact, in one of the controlled buys, he was on the porch, and at least according to the affidavit, he did not go back in the home. So he left from the porch, right?
I'm sorry, Your Honor, I don't remember that. From what I remember that an officer, one of the state police saw him on a porch, but from the controlled buys, I remember the CI calling him leaving the home, officers in contact, surveilling him to the buy, doing more surveillance, coming back home. And we do have that presence. This is a delivery service. So it's a little different than hand-to-hand exchanges, as you know, which does make a difference. And this is what the officers saw. There was total corroboration of them following the defendant from his home to the buy, also following the CI back to the meeting place, following the defendant who went directly back to the home.
But you'll just assume with me for a moment that the affidavit says that the defendant left from the porch without going back inside. Then do we have two controlled buys or some portion of the controlled buy? In other words, if for one of the buys, the defendant leaves from the porch without going back inside, is that tied to the residence as strong as opposed to if the defendant had gone back in the house or was in the house to begin with?
I think it is just as strong because the defendant didn't go anywhere else to pick up any drugs.
Right, but we have many cases that use against a defendant the fact that drugs can be transported in, small quantities that are sellable, and so it doesn't. We don't attach significance to the fact that you're not carrying things in and out of a house. So it seems like that cuts both ways, that we can't just always construe that only in favor of the Commonwealth. And here he could have gotten the drugs some other place, or we just don't know. We don't even know that he was in the house ever at that point. I mean, does the affidavit establish that the house was his house? I think there's a driver's license tied to that address, right?
There's a driver's license tied to the address. There was information, but it's not in the record whose house it was. He lived there with his family. Okay. But didn't come to the record who owned the house.
So you were talking about other cases and whether we've moved away from Smith. You rely on Commonwealth versus Mora, but in that case, just the existence of a controlled buy doesn't get the search warrant for the home, does it? You still need a nexus for the home.
Well, the direct observations of the officers would also help.
But what were those officers here?
Yeah.
Judge Wendlandt?
I'm sorry, I couldn't hear.
Yeah, I guess, yeah, here the observation of the officers is simply that he's leaving in the first controlled by from the porch, and in the second one, I'll grant you he was in the residence. So I'm not sure that there's much more than Smith here. It seems to be maybe 1.5 buys from the residence here. All the officers add in their observation is that they see him on the porch first, and then second from inside. They don't see, for example, a lot of foot traffic. We don't have the CI who's, you know, let's just assume we get beyond Aguilar Spinelli. You don't have the CI saying, yes, I went into the home to get the narcotics. I went to the home. I saw people in the home. I saw the defendant in the home with the drugs. I don't have any of that other things in the cases that we have, the ones that you cite that have, as you say, moved away from Smith.
And according to case law, which I don't have at the tip of my tongue, we don't have to have the CI saying that I bought them directly from the house.
No, but here, what do we have that ties to the house? You're saying the porch buy, you're saying the inside the residence buy, and I'm saying that sounds like Smith. What else do we have?
Just the officer's observations.
Of what?
Of him coming and going, of the defendant coming and going. That's.
Say that he goes and has short transactions and comes back, right? There's nothing other than the 2 controlled buys, is there?
There's nothing other than the 2 controlled buys, just other people that they saw later on the porch, which is sometimes relevant to a drug distribution where people help to package drugs, but that's basically.
See any of that?
Pardon me?
But they didn't see any of that. They just saw them hanging on the porch.
They saw them hanging on the porch. They didn't see them package the drugs, of course, but they saw them just hanging out on the porch. But the fact that the defendant.
So that can't be enough, right? You've got a bunch of people hanging out on the porch. That can't be the extra plus that we're looking for after Smith, right?
That's just what I gave it to you. That's what I had.
Understood. I completely understand. I mean,
honesty.
That's what I had. That was in the affidavit. But you have to look at the search warrant. Common sense. It's a delivery service. The defendant, from where we see, went no place else. And in delivery services, the drugs are usually there in the place, the home, apartment, whatever. Are there any other questions concerning any other areas?
I'm seeing none. And you have 4.5 minutes left. Do you want to use that for your second argument, or do you want to rely on the brief for that one? It's up to you, obviously.
The second argument is very strong. If your Honor wants to go through it, it's very strong. It was his bedroom. His clothing was there. His IDs were there. His wallet was there. Spoons with heroin residue. His brother, there was no evidence that his brother was in his room. There was evidence from the officer, the expert, that you usually don't let someone else stay in your room where you have the drugs, that you control the drugs. The brother was asleep and he had some marijuana in his own room where he was found, just from the money, college IDs, 2 licenses, social security card, in the other bedroom with a plethora of drugs. There's no doubt that that was the defendant's room. Unless the court has any other questions, the Commonwealth says that the 2 control buys are enough, and that the observances of the detectives were enough. The state detectives and the Broughton police detectives were enough, and the Commonwealth rests on the rest of his brief.
I just wanted to alert both parties, but I think the Commonwealth filed a supplemental appendix and it has the defendant's social security number unredacted. So you should probably take care of that.
Okay, I'm sorry. Thank you, I will.
Okay, thanks.
All right, thank you both. The case is submitted, fine arguments on both sides, so thank you.
Thank you, Your
At
Honor.
this point, we're going to take our morning recess after the attorney's exit, and that'll be a 20-minute recess just for those people streaming and want to come back once for the last week.
I'd like to begin with the what we characterize as the first issue, whether the probate and family court judge erred in finding that the marital partnership between Richard and Jerry Savoy continued up until the date of trial, when in fact Mrs. Savoy moved out of the marital home in 2006, leased an apartment in New York City, and split her time after that time between New York and Florida for the next 12 years. Mr. Savoy remained in Salem, Massachusetts. The parties stopped holding themselves out as a married couple, and Mrs. Savoy engaged in or began an intimate relationship with a third party. Only came back to the marital.
Can I ask
Sorry.
a couple questions?
Of course.
I understand that you say that as of 2000, they no longer had, but is it correct on that they continue to file joint taxes all the way up to 2016?
I believe it was 2016. Yeah, they did file joint taxes for a significant period of time after that. 2006.
Did she also carry the health insurance for the two of them?
I believe she did, yes, so long as she had it. She did. She had a group policy from her prior employer.
After 2016, did they also spend significant holidays together, like Christmas and?
So after 2006, when she moved out, yeah, certainly. So they did, and the findings of fact indicate that they spent. They spent holidays together. Mr. Savoy allowed and was happy to have Mrs. Savoy come back to the marital home to host her grown children for the holidays. I mean, I just want to make sure that we're clear. Mr. Savoy is a very generous and kind person, and he was very generous with the wife and her adult children when they were married and after the fact. I think that what is important to note is that the tenure of the relationship, the tone, the way that it worked, this was now him living in Salem, her living in New York, and he did welcome her back to the home for a few days during the holidays.
If I may interrupt you, I guess
Certainly.
I'm wondering, what is my standard of review here? Because the judge obviously found that the marriage lasted to the date of divorce. What usually findings of fact I review for clear error?
Yeah, so it's a great point, and I think that in this case the determination was in fact in the judge's findings of fact, but I would suggest it's really it's really a mixed question of law and fact, right? What happened between the parties during that period of time are findings of fact, and I don't dispute that, and we don't say that they're clearly erroneous, but the application of those facts to the law for the determination that the partnership ended, which is a legally significant determination, we believe is not subject to clear error. I also want to say that if I could just finish, and then I apologize for interrupting. Even if that's not the case, we believe that where the conclusions are not evident from the findings of fact, they are subject to reversal. And so we think that standard would apply here as well.
Let me ask you this. To the extent that they remained legally married, how much weight does that carry when we look at all the things that you suggest show that the partnership or the marriage had ended?
Well, so they were legally married. They remained legally married. But I think all of the cases that we see, and Savides in particular, talk about marriage as a partnership. And I think it's pretty clear that if there's a determination that that partnership, that both parties contributing to that partnership ends, that notwithstanding that the legal marriage may continue. And again, for purposes of valuing property, in the Savides case, the parties stopped living together in 1974. And I believe they were divorced 11 years later, but they were always married. During that period of time, the husband, like Mr. Savoy in this case, was extremely generous with the wife. I think he gave her a savings account to have unfettered access to. He paid for her to live in the home. He gave her money to travel. He bought her a new car. He did a lot of things that he probably would have done had they been married as well. But the court found that they lived separate lives. They were not living together. They both had relationships with other people, and specifically the wife ceased to contribute to the marital partnership. And again, even though they remained married for all that time.
When you say cease to contribute, why isn't the health insurance still a contribution, for example?
Well, the health insurance could have been something that the wife was required to continue to provide, even if they weren't married. I mean, I guess she wasn't, there's no evidence that she was making payments for that. The husband lived in the house. He co-signed the leases for the wife the wife lived in New York. I mean, this is not something that's disputed. The wife lived primarily in New York, sometimes in Florida, from 2006 to 2018, except for a small period of time when she moved back. And at that point, she asked the husband to move out. When she came back to live in the house for more than a few days, she asked the husband to move out, and he did that. And we think that's one of the most telling points here in terms of whether there really was, in the party's view, a continuing marital partnership here.
But physical separation alone does not define the end of a marriage, right? I mean, there are lots of reasons why a couple may say it's financially better, for example, if you go there because you're gonna, I don't know, have a better job, better income, maybe a better contribute. I have to stay here because the kids are in school, they have friends, whatever it may be. So physical separation may not necessarily mean there's an end of a marriage, right?
That's absolutely right, Your Honor. And I think that that is not necessarily dispositive. It's not dispositive. We just believe that in this particular case, there was no articulated basis for the move to New York, of the type that you've discussed. And you're absolutely right. It happens a lot, particularly nowadays when, men and women have careers in different places and different reasons for living perhaps separately for parts of the time. I think here, the difference is that there was never any expressed intent to to live back together ever, or really to continue to live as husband and wife. In fact, the wife had another relationship, and several times during this period, the parties discussed divorce. Now, they didn't proceed with getting divorced, but nor did they reconcile. I mean, there's no testimony that they decided, oh no, we're not going to get divorced. We want to give it another try, just for whatever reason. And again, I don't know what those reasons were, but they didn't proceed with a divorce. But they certainly never expressed any intent to rekindle the marital partnership during that period.
So counsel, the wife seems to be arguing this is a bit of an academic issue because neither party offered valuations of the property in 2006, of the assets. What do you say to that?
I think there is evidence in the record, Your Honor. The judge didn't talk about it, but she didn't value it as of those dates. And in fact, there's testimony and documentary evidence in the record from which one could determine the valuations.
And do you tell us where that is?
Well, we reference it in our not findings of fact, in our procedural history and facts. And I just want to note that with respect to every fact that is material in our view to your determination here, we have a record citation, and it's either to, there were 2 days of trial testimony, it's either to the trial testimony, documentary evidence, or to the judge's findings of fact, many of which we don't dispute. And in fact, we feel some of them were supported by the record evidence.
Can I ask you to turn to the trust issue?
Of course, yeah.
Are you
Certainly.
aware of any legal authority for the proposition that an open beneficiary trust is marital property?
So not for that specific proposition, but I would draw the court's attention, if I could, to a case that we didn't raise in our brief. And it's a case called Levitan versus Rosen. It's an appeals court case from May of 2019, 95 Mass App Court at 248. In that case, there was a trust that was very similar. The wife had an interest in a discretionary trust. Her share had vested upon her father's death, which is exactly what the court found here. The wife was the trustee, but there was also another independent trustee, which we don't have here. And the wife had taken distributions during the course of the marriage. That was a trust that was governed by Florida law. And in fact, the court, as is this trust. And in fact, the appeals court found that in that case, when interpreting provisions of a trust under Florida law, the guiding principle is to determine the intention of the settler, and cited to Florida cases. And just for reference, at page 251 of the Levitan discussion. I want to note that in this case, the judge made an express finding that the wife's interest in the trust property vested upon her mother's death, and that she was the primary beneficiary, and that the only contingency, which is the mother's death, right, that could result in her not having being entitled to the trust property had already occurred. So that wasn't going to occur. And the wife had unfettered access to the funds in that trust. And in fact, between 2013, when she became the sole trustee, in 2018, she had distributed about $1,800,000. And I just want to draw the court's attention, if I may, to Article 16 of the Fitchett Trust, which can be found in the record appendix at page 50. And it expressly says, in the management, investment, and distribution of trust property, trustees shall consider vested and first beneficiaries as trustees' primary interest and responsibility, and trustees shall consider contingent or remainder beneficiaries as trustees' secondary interest and responsibilities. The wife was an only child. She had no siblings, so she was the first and the only vested beneficiary. Her children.
Can you explain that to me? I think I completely disagree with you as a matter of law.
Well,
everybody who is a lineal descendant of the wife's mother has a vested interest in this trust.
Well,
there's nothing left.
But everything, the wife is entitled to use the trust money for her maintenance. She's the trustee, and the only limitation is that she use it for her maintenance, support, education, medical expenses, I believe the language is. So while the other beneficiaries they're certainly not the first vested beneficiaries. We believe that the wife's interest became vested when the mother died. The wife could theoretically have drawn down the entire, all of the assets of the trust by the time, at any time during her life, right? So prior to her death, it was exclusively to her discretion in terms of how she used that trust money.
Well,
and
that fiduciary duties, right? I mean, I think the problem for you with the Levitan case is that it specifically distinguished a trust that had an open beneficiary class. And here we have an open beneficiary class.
Well, I think that's right. And I guess I would just refer you, because I'm almost out of time here, I see, to the judge's very detailed findings of fact, where she basically finds that subject only to her own discretion. The wife in this case could use that money, in fact, did use that money, and had an enforceable right to use that money so long as it was for her maintenance or support. And the wife used $1,900,000 worth of that money for that purpose.
The wife argues that this argument is, the trust argument is waived, that you did not argue below that the trust, the trust property should be included within the assets of the marriage. Can you point to us where that was argued below?
So I cannot point it in the record where it was argued. I was not trial counsel, but that's not an excuse. I'm just indicating. It was not specifically argued because the point was, and the argument and trial counsel believed that the proper date of valuation was 2006. If that were the case, then there'd be no reason to include it as a part of the marital estate, because the wife did not become the sole trustee and her interest had invested until 2013. I will say that in the event you were to find that it was not raised below, because it is briefed very thoroughly in the parties' submissions, and there's sufficient evidence in the record to reach the issue, you do have the discretion to reach the issue. And that's, of course, I'm sure you know, under the Imprimis Investors versus KPMG case, which is a 2007 appeals court case. And I see I'm a bit over, so if you have other questions, I'm happy to address them, but otherwise I'll rest on the brief.
Seeing none, we'll turn to Mr. O'Regan.
Good morning, Your Honor. May it please the court. My name is Robert O'Regan, representing Geraldine Savoy. Joining me at the virtual counsel table is attorney Heather Cahill. I believe she's through the YouTube connection and not through the Zoom. In the time I have this morning, I'd like to focus really on 4 discrete issues. The first is, and has been alluded to in the course of the arguments earlier, there's no showing of plain error in any of the supporting or subsidiary facts by the trial judge. There was a comment made about the tenor and tone of the decision. The tenor and tone of the decision below, in the exercise of the trial judge's discretion, is for the trial judge. If the findings of fact are not shown to be plainly wrong, there's no argument here that they were.
Do you agree that the date of marriage when it ended is a finding of fact?
Yes.
Yeah.
And in fact, as I'll get to in a minute, that was a specific finding of fact this judge made based on the credible evidence. The second, well, the sort of sub-argument.
I guess your sister, more to the point, says it's a mixed question. I'm wondering what your reaction is or your response is to that.
My response is the date of when the marriage ended is a question of fact. What to do with that particular finding of fact as to the length of the marriage would apply the criteria under General Law Chapter 208, Section 34, with respect to, in this case, the division of marital assets. And so it may have been, it's not the case, that the judge decided the marriage in fact ended in 2017, but that the contributions waned in a certain period of time, and therefore there was weight given to how various assets were considered. That was an option available to be argued below. It wasn't. That's an example I would use to say how the finding of fact that the marriage ended on a particular date is one of the findings of fact the trial judge would make. And it needs to be in the opportunity by the parties to have the judge put that finding in connection with, say, opportunity, the contribution to acquire and develop assets. So there could have been, between separation and natural termination of the marriage, assembly of assets to which one party gave greater contribution, and the division would be weighed differently. None of that was argued here.
Was the issue of the trust being a marital asset argued?
It was argued as to whether it should or shouldn't be in the estate. It was briefed and determined.
So it was not waived?
Well, I wouldn't say it was technically waived. The issue was, once it was determined what to do with it, was never really developed by the other side. And you even see this in their approach, which is my next point in my overview. There's no argument here that when the judge exercised the decision to count this trust as an opportunity for the acquisition of assets or income in the future by the wife, that the way the judge weighed that, the way the judge gave a lopsided division of the invested assets in favor of Richard, why that was an abuse of discretion. So this is not a case where the judge disregarded the trust in the property division. This is a case where the judge took it into account, assigned it weight, and made a property division that allocated the weight in respect to the investments in favor of Richard, 60 and 40% to Jerry.
But
So
the question whether the trust is a marital asset is a legal one, is it not?
yes, it
Okay.
is.
So we review that de novo. And I'm wondering, given the finding by the judge that your client had unfettered access to the trust assets, including principal and income, that she exercised that from the time she became the trustee in 2013 to date, why this falls on the side of an opportunity and not as a legal matter, as is on the side of a marital asset?
Because the legal rights, the legal ruling depends on the language of the instrument.
Well, not just the language of the instrument. You say that in your brief, and I have to take issue with that because it's not the language of the instrument in isolation. It's the language of the instrument plus the facts and circumstances of the case. So each of the cases that both parties cite look at the actual treatment by the trustee of the assets of the trust, not just the instrument. Or do you have a case that just looks at the language of the instrument?
The Pfannenstiel case is the clearest example where the view that the trial judge and the view that the appeals court took was solely dependent on an assessment of what the facts were and, if you will, what the real world administration of the trust and futures were. And when the Supreme Judicial Court made its decision, the clear language is that the analysis of the legal determination as to whether that interest, that trust interest, is sufficiently certain to count as a marital asset was purely a question of law based on an analysis of the instrument itself. And I submit that if the language of the instrument identifies it as not sufficiently clear as a property interest to be a legally enforced, presently enforceable right, but nevertheless the conduct of the parties or the trust is different from maybe the language of the trust, that's where the judge would have discretion in weighing the opportunity for future acquisition and income in the overall property division. But the asset itself, that is the beneficial interest of the trust, would still not be a divisible asset. So in this case, the judge correctly did not include the principle of the trust as a divisible asset, but I think correctly included what Mrs. Savoy was able to do with the income and assets to her benefit in giving a lopsided division of what she identified as the legal interests that were sufficiently certain to constitute marital property.
Sorry. Okay. Is there anything in the record as to whether your client was drawing down just principal or just income or both?
The detail of the distributions out of the trust are not that developed in the record, but I think everyone would agree that she was drawing income and principal. And there wouldn't have been enough income to draw the total that she took. Wish there were, but there weren't.
I mean, could she lawfully withdraw every dime out of this trust and leave nothing for the rest of the beneficiaries?
I think not, because under the language of the instrument, distributions of principal to herself are governed by the ascertainable standard, and the other beneficiaries could hold her accountable for distributions to herself that violated that standard. One of the requirements in the instrument is that distributions that she makes are disclosed. The evidence is uncontroverted that she did consult with her children about those distributions. In fact, the judge made findings that the children were on the account, had online access to the accounts to monitor the accounts. The issue would be whether in making distributions to herself, she violated her fiduciary duties to other beneficiaries and therefore would be liable to them to basically put the money back.
Yeah, from
That's
2013 to the date of the trial or decision, no other beneficiary had ever raised a hand to say, you're breaching a fiduciary duty here by drawing down so quickly this trust.
There's no record anybody did, and the only evidence was that the children agreed that she could use the funds as she did. One of the examples were to acquire some property, and the evidence, and the judge found, is she told the children she would pay that money back to the trust. So there is evidence that there was disclosure and involvement in by the children in the distributions that she made from the trust. That doesn't make the trust interest a divisible asset with Richard in the divorce. What it does, this reinforces that the notion that it does count as for a judge to weigh her access to that, perhaps against her, in dividing what are the marital assets.
If we conclude that as a matter of law, this was a marital asset, what then?
Well, the only outcome would have to go back to the judge, and the property division would be reopened. The judge's analysis that the availability of the trust to support her going forward, and therefore she would not need alimony from Richard, that finding would have to be retaken. The whole trial would have to be recast. All the financial analysis of the parties' lives going forward would have to be recast. I submit that is a reason why the statute is written the way it is, and the discretion of the trial judge to do with the assets within the judge's discretion is a sound one.
Why do you say
there's no
there would
law.
have to be a trial, a retrial?
I'm sorry?
Why do you say there would have to be a retrial? I don't understand that, because it seems like if we conclude as a matter of law that it's a marital asset, the judge then again has discretion to even reaffirm the distribution currently made, 60-40.
Well, then, if you view it that way, I'd say, where's the error? Because even if the judge was wrong as a matter of law in the exercise of discretion, there is no requirement, and my sister doesn't cite a requirement, that even if something rises to the level of a sufficiently certain asset, it must be divided. There are 4 steps. One step, what's being discussed? 2, is it an asset? 3, is it an asset that will be divided? 4, if it is, how much? And so in steps 3 and 4, that's totally discretionary by the trial judge. And here in the rationale, the trial judge indicated clearly that she would not divide it in kind, but she on purpose would allocate the weight to the opportunity to acquire future assets and income.
But it would give counsel an opportunity to make an argument as to why it might be circumstances to be divided differently, right? I mean, she could do the same thing. The judge could do the same thing, or the judge could say, now that I know that I made an error of law on this one asset, I might want to recalculate how the division goes. So it doesn't necessarily lead to one outcome or another.
And I may have spoken, it might not require a new trial, but my experience is after a remand like this, on issues like this, one of the questions a trial judge would have would be, what further proceedings do counsel believe would be appropriate? Would further evidence be required to address whatever issues the appeals court identified? Here, the way the judge made the decision, first of all, I don't retreat from the position that the judge was correct in determining this trust was not legal, a marital asset. And I do submit that she allocated it appropriately, and that it would have been well within her discretion to, even if it were a marital asset, to have not included it for purposes of equitable division. She was clear in her findings that the husband made no contribution to it whatsoever. She was clear in her findings what the decedent's intent was, is to benefit her daughter and the lineal descendants. And she was clear in the findings that post-separation, once Jerry, I'm sorry to be familiar with my client, but once the wife became eligible for these distributions, the husband stopped paying her monthly support payments. Those are all facts the judge weighed in deciding how to deal with this interest in the trust and give a lopsided property division.
Can I just, I know that earlier you had said that how to allocate the trust, or how to, whether view it or an asset, is certainly based only on the language of the trust. Are you suggesting that there's never a circumstance that, even though the language is clear, the way it's been used and the fact that someone may have control over the lineal beneficiaries might lead to suggesting that maybe the language alone is not how court should view it as an asset or not?
That identifies the distinction between a question of law and a question of fact. It is solely a question of law as to the beneficial interest in question. The next issue is as a question of fact. What is going on with that interest? Take as an analogy, I would put to the way people behave with closely held businesses, which are always a difficult question in divorce cases. And so judges find solutions to those, looking for substantial justice in fairness. And that is one of the tools in the very generous phrase, opportunity to acquire assets and income in the future, within the statute, where the judge can be clear in what the judge is doing in the exercise of discretion. And I think that for purposes of property division, it is important to make a clear line between questions of law that will follow the legal instruments, whatever they are, and questions of fact that do otherwise. I see my phone is telling me my time is up. And so I refer to the arguments in the brief, and unless there are no more questions, I'll rest.
Seeing none, your arguments are both submitted. Very interesting case, and argued well on both sides. We appreciate it. Thank you. You can exit.
Defendants, Mayor and Markey, because the trial court erroneously extended the federal common law doctrine of derivative discretionary function immunity to state contractors working under a contract with the Massachusetts Department of Conservation and Recreation, DCR, in a program that was grounded solely under state law. There is no federal law or regulation that authorizes the United States to regulate living, mature, stationary trees on private property. All authority for the program that we're talking about today was based on state legislation under Chapter 132, Sections 8, 11, and 12.
Now, the supervisor, though, was a federal employee. Is that correct?
That is correct. The supervisor was a federal field technician who was working. I'm sorry. So if they acted under the direction of to remove those trees by a federal employee, why isn't that enough to invoke the discretionary immunity? Well, it gave the federal employee discretionary immunity, as the First Circuit found. It does not give this state contractor who's working under a contract, a very detailed contract with very strict specifications, immunity, because the contractor's relationship is not with the United States. It's not with this federal employee who just happened to be, by random chance, the supervisor that day. She was nominally supervising them that day. However, the United States does not have control or enforcement authority over the contractor. The state of Massachusetts had that authority under the contractor. The state required this contractor to, and it's a very detailed contract. It's called the FAC 47. And you can see that the relationship is between the state and the contractor. The contractor had to post a $1 million performance bond to the state. The contractor had to name the state as an additional insured on its $10 million insurance policy. The contractor had to provide indemnity to the state. The United States is not mentioned anywhere in that contract.
Did the contractor, did they have the right to ignore the directive of the federal employee?
I believe the contractor had an obligation to obey its contract with the state that required the contractor to be in receipt of a permission slip signed by the property owner before the contractor entered the property to cut trees. And if it didn't have that, I believe the contractor could say, wait a second, I want to see the permission slip. That may not have been what they did out in the field, but that was the contractor's legal obligation. And that was exactly what the state's policy was. DCR implemented this policy intentionally to protect property owners.
But counsel, you say though in your brief that Markey removed the 21 trees at the specific direction of a federal employee.
That was exactly what this court found back in 2016 in its decision. And that is basically undisputed. Yes, they decided to follow that direction. I can't get around that. That's what happened. But the federal employee and the federal employee was cloaked by a discretionary function immunity. The United States has sovereign immunity, but the contractor worked for the state. This was a cooperative program, but the role of the federal government was based on the state having the authority to remove these trees. The federal government had no power to remove these trees. The federal government provided funding, provided personnel, but the state—
And that's because, so you're saying the federal government only had power to say that this wood had to stay in a particular geographic area, I guess within Massachusetts, to prevent the spread, right?
That is absolutely what the federal law, that's the full extent of the federal law. The federal law also says, the Plant Protection Act at section 7751 says that the federal government may cooperate with state entities to eradicate pests like the beetle. However, it can only do so if the state entity has the authority to act, to take operations in state land. Without that, the federal government can't do a thing here. So
well, if they're standing on the land and the federal employee says, cut that tree down, and the contractor says, no, what happens?
the contract, they should go and talk to the state who supervised this contract. The state had a project manager. The state, under its agreement with the feds, had the lead official, and the state also created the policy that required prior property owner permission. So if could it have caused a problem? Sure, it could have caused a problem, but the contractor's obligation is ultimately to the state and to follow the state's specifications.
If the federal government had no authority and no role here, then why was the federal employee there on the land directing these people to cut these trees down?
They had both federal and state employees monitoring cutting crews. They were providing personnel to assist the state in this program. It was a cooperative program funded by the feds primarily, but it was based on state law, solely on state law. And therefore, the contractors had a contract with the state. And the contract actually says that the contractor must indemnify property owners identified in their permission slips for breach of the contract or for any negligence by the contractor. So here, the federal government had no control, contractual control over the contractor, and it had no enforcement power over the contractor. Did it have nominal supervision that day? Yes. Was it customary for the federal employee to go out and identify the properties that had given permission for their trees to be cut? Yes, that was customary. And in fact, what happened here was the federal employee mistakenly believed that Mr. Evans had granted permission for his trees to be removed. And the investigation by the director of the federal program confirmed that Mr. Evans had never given permission. There was a mistake made by the field employee.
If there was a contract between the federal agency and mayor, then your position would be over, right, under the Boyle.
Yep.
Okay.
I have to
So
concede that, absolutely.
your position is that federal common law, which is the genesis or the reason for this derivative immunity, does not apply here because it's a state agency contracting with a private party.
That is exactly our position.
Okay.
And I believe if you follow the the analysis of that's in the federal common law regarding derivative of discretionary function immunity, you'll find that follows. The cases relied on by the trial judge, frankly, support my position. The Second Circuit opinion in the World Trade Center disaster litigation says that it is essential to find that the federal agency exercise supervision, control, and enforcement authority over the contractor. Mere cooperation with the state does not warrant an extension of derivative immunity.
But you're telling us that here the federal employee had supervision power over Mayor and Markey, if I understood. Or you're saying we previously found that. We don't know findings, but
I'm sorry, Your Honor. No, I don't believe that the court previously found that the federal employee had supervision power. It said that the federal employee directed them to cut the trees. There's no way around that because I know that's what the facts are. But that doesn't mean that the federal employee had control and enforcement authority over these contractors. The only authority the feds had here was authority that was delegated to them by DCR. And that authority could not have been more than what DCR itself had. And our position, as laid out in the prior opinion of this court, is that DCR promulgated a policy of requiring prior written permission from a property owner before entering his property and taking his uninfested trees. It's replete throughout the record here. There's the removal order that had attached to it a permission slip. There's an email from the lead DCR employee on this when they were formulating that permission slip. There's testimony by the director of the federal program, Christine Markham. There's testimony by Michael O'Brien, the city manager of the city of Worcester, all of whom said this was the program. We're not going to take out the trees of private individuals unless they're uninfested trees, unless they give us written permission.
Now, was there evidence that you indicated customary practice that the federal agent would say, these are the trees you need to cut down? Was there customary practice of them showing or of the contractor asking to see the permission slips?
There's no testimony with regard to that.
Is there any evidence that the contractor had the permission or the denial of the permission slips in this particular instance or in any other instances?
There is no evidence with regard to that, but the contract is still there.
Okay. Could the customary practice that had been ongoing be enough to give this derivative
immunity?
Immunity.
Your Honor, I would say not, because the practice was to make sure that the property owner had given written permission. The reason that they took out Mr. Evans's trees is they mistakenly believed that the property owner had given written permission. There was either a mistake made in the paperwork at the office or the field employee made a mistake in understanding the paperwork. That was the conclusion of the director of the federal program when she investigated this. There was never, and Mr. Evans never got the notice and the permission slip until 10 days after his trees were cut.
And under the statute, it's strict liability, right? The fact that it was a mistake doesn't matter.
The fact that it's a mistake doesn't matter unless they had license, unless they were lawfully authorized to enter and remove his trees. And our position is he could not have been because of the state policy and because of the state contract.
So counsel, do we have discretion whether to accept the reported question? Because it seems to me that even if we were to rule in your favor, the defendants have at least a couple of arguments, and both ways, actually. If we rule in their favor, you have arguments to still argue there's liability, because it seems like you might be asserting some sort of third-party beneficiary contract claim. So we don't like to decide things piecemeal. And this is your second trip here, and I anticipate at this moment a third trip, if not a fourth. So why should we decide this?
For one thing, we need to get this issue out of the way because it's not going to go away first. I honestly, as I sit here, couldn't tell you. I would certainly try to assert a third-party liability claim if I'm able to 11 years after the trees were cut, and I might be able to. It certainly has occurred to me, but it was not pleaded. It was a strict liability claim that was pleaded by predecessor counsel. I think all parties would prefer that the court decide this particular issue. Does this court have discretion to not decide the question? I think this court always has discretion to do what it wants. Can I help with anything else? Because I see my time is up.
So your opponents argue that Yearsley controls. If they're correct, can you still win?
Yes, because here again, the contractor had to be doing the government's work. The government here is the state. It's not the federal government. And Yearsley is part of the control here. But if you look at the cases, you have to look at Boyle. You have to look at the two World Trade Center disaster cases. They all flow from Yearsley, but Yearsley by itself is not enough. You have to go to Boyle. You have to find if there is a uniquely federal interest that is at stake here, and whether there is a significant conflict between application of the state law and the unique federal interest here. There is no uniquely federal interest here because the state and the feds have the same interest to eradicate the ALB. And there is no conflict between that interest and enforcing 242 Section 7 because the state essentially embodied that in its own contract and in its policy requiring property owner permission for eradication, for removing uninfested trees.
Okay, let me check if there are any other questions. Any other questions?
No.
Okay, no other questions, and your time has more than expired, so I appreciate the argument. Thank you.
Thank you, Your Honor.
All right, Attorney Tremblay, are you going to go first?
Yes, good afternoon, Your Honor. May it please the court, Denise Tremblay for the defense.
Hold on 1 second. We have a clock that says 15 minutes. Do we have a 10-minute clock? Okay. All right, you may begin.
Denise Tremblay for the appellant Mayor Tree Service. I'm going to be arguing the issue of derivative immunity, and then Mr. Scamby will address the other issues raised by Mr. Evans. In this case, essentially, the First Circuit has unequivocally determined that the USDA, APHIS, and their agent on the ground.
Counsel, do you have any cases where this derivative immunity has been applied in a case where the contract is with the state?
Yes, in the INRAE World Trade Center disaster cases, That case involved a situation after 9/11 where there were multiple contractors, state contractors, independent contractors, firemen, policemen, and they were acting under a cooperative arrangement similar to the one in this case, where both the federal government, the state of New York, and local governments were all cooperating to clean up after 9/11. And the court, the Second Circuit decided that the individual contractors, including firemen and policemen who had contracts with the state, were entitled to derivative discretionary function immunity under federal law. And that I believe that In re World Trade Center cases are central to making a determination in this case, because they are the most factually similar, and they include claims by plaintiffs who were not in a direct contractual relationship with the federal government, but they were all acting under the direction and scope of a cooperative agreement that included the federal government, and they did not act outside of the parameters of what they were being instructed to do. In this case, the First Circuit has determined that Franciosi, the technician on the ground, had the discretionary authority to instruct Markey, who was cutting the trees, to cut the trees. Neither mayor or Markey could designate a tree for cutting.
Counsel, Mr. Attorney Cederholm would argue that the federal employee had no more authority than DCR because these trees were stationary because they hadn't been cut down yet, and that the federal government didn't have any authority vis-a-vis its status as it's being the federal government. It only had authority through the state government. So what do you say to that?
That is an incorrect statement of law. That the First Circuit has determined that they did have authority, and the First Circuit cited 4 things that gave the APHIS authority. The first is the federal quarantine order. So the APHIS had, under 7 CFR section 301.51, it had the authority to quarantine an area within a state. And it had the authority to control what happened to the trees in that state, including the authority to cut them down. And that is actually also in the cooperative agreement. The cooperative agreement states that the primary goal of the agreement is to support the USDA and APHIS in eradicating the ALB within the Commonwealth of Massachusetts. Under objectives in that agreement, it states prevent the interstate and intrastate spread of ALB. And also the DCR quarantine order stated that it is authorized to confer upon APHIS all of the same powers that it has under state law. And finally, FAC 47, which Mr. Evans argues did not give any authority to mayor to act outside the scope of DCR, states under section ID that all work within the affected area shall be performed in compliance with the cooperative agreement, which is with the USDA and APHIS, and the technical specifications of FAC 47 state all ALB program marked or designated trees shall be cut. Neither mayor nor Markey had any discretion if either a DCR employee or an APHIS employee instructed them to cut a tree. They were required to cut that tree. They could not designate a tree for cutting. They had to do what they were told to do under the cooperative.
What's the authority for that last proposition, that if a federal or state employee said cut a marked tree, they had to?
There is deposition testimony that's cited in the record. And then I'm also looking at Fact 47, which is Exhibit I in Volume 3 of the appendix. At the end of that document, there is a page where it's entitled Technical Specifications, and it requires that all trees that are marked or designated shall be cut. And neither mayor nor Markey had the authority to mark a tree or designate a tree.
But isn't that slightly different than the proposition you're saying that sustains? I mean, so they have to cut trees that are designated is not necessarily inconsistent with also having the obligation under the contract to check to make sure that they have the property owner's permission.
As a matter of fact, that has been a red herring in this case all along.
If you explain that to me? Yeah.
Yes, if you look at Fact 47, it refers to Exhibit C being a property owner permission. There is no Exhibit C. That no one in this case, there is no Exhibit C. You will not find one in the record because there is not one. It was, and representatives of both mayor and Markey, as well as representatives of the USDA, all testified that, in fact, mayor and Markey were instructed not to have any interaction whatsoever with owners. They were not even allowed to speak with them. The only interaction that they had, and that is why there was a representative on the ground. They could not do anything unless they were told to do it by DCR or APHIS. If they were told to cut a tree, they cut a tree. If it wasn't designated, they could not cut the tree, and they were not allowed to speak with property owners.
But that does not allowed to speak with property owners mean, or no interaction mean, that they were not allowed to see the permission slips?
There were no permission slips. There is no Exhibit C.
It was for this property, you're saying for any of the properties, that wasn't something that they were necessarily given. Is that what you're saying?
They were never given an Exhibit C, and they had no ability to
access that.
I'm sorry.
And they had no ability to ask for it or access.
No, they could not. They would walk the property before the cutting was done with the representative on the ground, whether that was DCR or APHIS, and that individual, Crystal Franciosi, actually, the testimony from the First Circuit case determined on the day of the cutting that at least 14 of Mr. Evans' trees were in fact infested. So those trees were coming down regardless. She made a determination. She told Markey which trees to cut, and Markey cut only those trees that they were told to cut by Ms. Franciosi.
Okay. There was evidence that 14 of the 21 trees were infected?
Yes, it's in the First Circuit decision. There is a note that she had testified. She had given several statements, and she did at one point state that on the day the cutting was done, she observed 14 of those trees to be infested. That was her testimony.
And that's, we're at summary judgment?
No, that was the First Circuit's affirmation of
summary. No, here, we're at summary judgment?
Yes.
Okay. And you're saying in the light most favorable to the Evans plaintiff, that is the evidence?
Yes, that is.
In the light most favorable to Evans?
That is the evidence, yes.
Okay, so she didn't waffle on that. It was always 14. That's your testimony.
It wasn't always 14. It was, okay. There was...
It wasn't, oops, there's a mistake?
It's complicated. The USDA...
I'm just asking in the light most favorable to the plaintiff, which is our standard of review.
Right.
You're saying that light most favorable requires us to assume there were 14 infested trees?
No, I think that's completely irrelevant to your decision. What matters, it doesn't matter if the trees were infested or not infested. Markey was obligated to cut any tree that they were told to cut under this cooperative agreement, which was an agreement involving both the state and the federal government, and DCR conferred upon the federal government its same powers. If you look at the mass quarantine order and the cooperative agreement.
So you're saying even,
Counsel, there
though-
was a, go ahead, Chief. Counsel.
So you're saying even though the contract was with the state's contract or cooperative agreement is subsumed in that contract, and therefore that's why they were required to cut any tree that the federal agent told them to cut.
Correct. Fact 47 specifically references the cooperative agreement and states that the contractor must comply with that cooperative agreement. And the Fact 47 also states that they shall cut any designated tree.
You said Exhibit C doesn't exist, but we do know that owners were asked their permission with some sort of permission slip, right?
Yes, that's true. That is DCR had developed, and this is also outlined in the federal court decisions. DCR had what they considered a courtesy. There were people in Worcester who were very upset about trees being cut. So in an effort to be collaborative with the community, they developed a procedure where DCR, not mayor or marquee, had a form letter that it would typically send out, and that was that they would ask permission. But this was not anything that either marquee or mayor was involved in at all. And this, as a matter of fact, the First Circuit found that even if DCR had adopted a policy of requiring property owner permission that it needed to get, these were mailed out from DCR headquarters. This wasn't something that mayor or marquee did. But even if DCR had that policy, that policy did not rise to the level of a federal law, and it did not in any way diminish the APHIS agent's ability or discretion to order that a tree be cut.
Okay, seeing no questions, we'll turn now to Attorney Scamby.
Good afternoon, Your Honors, and may it please the court. There was some discussion during Attorney Cederholm's presentation about the claims in the case, and I would suggest that cannot be understated. We have 2 counts in this complaint, which has been, as noted, filed quite some time ago. There is a statutory claim under the trespass to trees state law, and then there's a 93A. There is no count for negligence. There is no count for contract, whether it is an intended or some type of third-party beneficiary theory. So the only issue in consideration of whether there's a sufficient basis to proceed under Chapter 242, Section 7, is whether the contractors had license. And look at this court's 2016 opinion. 2 lines are particularly important, I'll suggest. On page 148, this court noted, it follows that a contractor who had been duly authorized to destroy privately owned trees as part of a statutory nuisance eradication program would have, quote unquote, license to do so, and therefore could not be liable pursuant to Chapter 242, Section 7. That's significant. And when we look at page 150 of the 2016 opinion, the courts, and essentially what formulated, in addition to what the court found to be an insufficiently developed record, what the court found in reversing this and sending it back was that Franciosi, the USDA agent on the ground who undisputedly gave the contractors the instructions, her mistaken instructions could not provide, quote unquote, license if her instructions were legally invalid. We have an opinion from the First Circuit which rejected the idea that her instructions were not legally valid. We are dealing with a concept of derivative immunity, and essentially the federal government here was found to be entitled to that protection, that immunity. And when we look at the case law that extends that protection to the contractors that are directed by the federal officials, there's other.
Counsel, Attorney Cedarholm's position, I think, is that you have that Meyer and Markey undertook contractual obligations to DCR that might, I think, sever that situation with the federal employee. In other words, they said, we won't be cutting any trees down unless the homeowner gave permission. And so whatever the federal government was doing is just over here on the side. And so we're looking at this obligation they undertook. So I take it one response of yours would be, well, the contract is not at issue because they didn't make a contractual claim. Okay.
Right.
Is there another response besides that?
Yes, and the other, that's certainly the response, but the second response is that, and I disagree with Attorney Cedarholm on this, the idea that the USDA was not authorized to do what it did.
No, I don't think the question is that the USDA was not authorized to do what it did, but that when they did that, there was still a separate obligation to make sure that the order complied with the state contract or the state directive not to cut any tree that was not infected and for which there was no permission.
Yes, and what we end up coming back to is the fact that there is no claim in this complaint, in this very, very old suit, for a breach of a contract, for negligence, for third-party beneficiary. And I agree with Attorney Tremblay. This permission slip has been, and it remains a red herring in the case. It wasn't even attached to the contract. And all of the evidence that was developed in the record suggests, and it's unrefuted, that the contractors did not. They were prohibited from getting, going to private property owners and asking for permission slips. The parties are certainly free to waive a private contractual arrangement that they make. And absent some claim, we're dealing again with a single statutory claim that turns on this question of license. And as this court found in 2016, if the contractors had license, they cannot be liable, not under the statute. And because we don't have other causes of action to consider here, it just, there's really nothing, there's no question of fact to give to a fact finder on this issue of license.
You know, we sometimes talk about this option of the buck stops here, and that where you've got a lot of moving parts, as it sounds like was definitely happening in this situation, that, you know, people can build in fail safes. And so Attorney Cedarholm might argue, well, this was a fail safe that was built in, that the contractor, maybe they couldn't go ask the property owner for permission, but that somebody should be looking at the checklist and saying, yes, we have a permission slip, or no, we don't. And it seems like he's arguing that Meyer or Markey failed that obligation. So what do you say to that?
I say that could be evidence in a different type of a claim. I would say that that's not relevant to the question of whether the contractors had license as contemplated by Chapter 242, Section 7. And because there are no other causes of action to consider, and I would suggest that this question, there is no question to present to a jury as to whether they had license, because you'd be asking a group of lay people to decide whether an instruction given by a federal employee was legal.
Right, well, so let's talk about that for a minute though, because he's arguing that when you're only within the state, which, you know, when you're only in the Worcester area, that the federal government had no authority. And you've said that the Department of Agriculture had authority. Is there some citation for that other than the First Circuit decision? Is there a statute that gives them authority?
I believe Attorney Tremblay addressed the various CFR. I think there's a Plant Protection Act. There were numerous, and I believe the First Circuit as well addresses the authority of the government. And I think we'd have a whole different case here, Your Honor, if there was actually a claim that the USDA had no business being there or no authority to be giving instructions to anyone. There was certainly a federal interest here. Otherwise, the federal government would not have been involved. I mean, there was a serious concern about the spread of this insect and how it's the devastation it could cause to the forestry, obviously across state lines, and efforts were made to combat the pest and to control it and remove it. And in the end, Your Honor, what we're left with is a situation where you have private contractors on the ground with equipment and a federal employee saying, here are the trees to cut down. The federal contractors was found, the federal government was found to be entitled to the immunity by the district court and then the First Circuit. And I just don't believe that the law permits a stripping of immunity because of a contract between the contractor involved and the state, simply because the state wasn't on the ground giving directions that day. We were following the instructions.
Your position is that the state contract is basically beside the point, that you have it's as simple as a federal employee said, cut these trees down. The federal employee did in fact have authority to do that, and they did it, and we're done.
That is correct, Your Honor. Any other, I'm all over time, Your Honor, so any other?
I see that. All right. And seeing no other questions, the case is submitted. Very interesting case and well argued on all sides. So I thank you very much for that. Thank you again for agreeing to a virtual argument.